Hello folks, here are some tips on trying criminal cases to a jury. First of all, jurors believe advocates and lawyers who are brief, extremely focused, and make appropriate, even bold concessions. The best place to do this is in the opening statement. Many times I've seen, and my colleagues have seen, lawyers who in their opening statements agree to most of the prosecutor's case, or even prosecutors who agree to many points expected to be made by the defense. When jurors see lawyers separate the irrelevant from the key issues, they credit that advocate and they see that lawyer as a leader, as a teacher, as someone that is going to lead the search for the truth. Another point, if you're looking for an advocacy style, look to movies like My Cousin Vinny, in all seriousness, as opposed to other more lawyerly movies. If you're going to try cases to juries, then you want to be less like a lawyer and more like a real down-to-earth person. Think about it in this way. The way you want to talk to a jury is in a slightly more polite version than the way you talk to your grandmother at the dinner table. You don't want to talk like an intellectual. You don't want to talk like a fancy lawyer, because nothing separates you more from jurors than to talk like a fancy, well-educated person. It only separates you from the wide socioeconomic situation of many jurors. Criminal lawyers, whether you're a prosecutor or a defense lawyer, should be aware of jury nullification. Now, jury nullification, of course, is when a jury basically decides, perhaps explicitly, perhaps only implicitly, that they, even though they are aware and agree that the defendant has been proven to be guilty beyond a reasonable doubt, they feel some sympathy, some human compassion for the defendant, and they find him guilty or her guilty of a lesser charge, or find the defendant not guilty. It's much more likely to happen in a less serious case, and in the more serious cases, it often will play no role or will only affect the degree of guilt that is found by the jury. But any good criminal advocate, any good criminal lawyer should be aware of the role of jury nullification. The law is, in short, that you may not argue jury nullification, but one should be aware of the possibility of jury nullification so that one's arguments can implicitly, at least, address this basic human drive that some juries have for jury nullification. And it doesn't matter whether you're the defense counsel or the prosecutor. In a criminal case, in modern times, you must either defend or criticize the quality of the investigation. At a minimum, you should consider whether the quality of the investigation should be criticized, and you should consider whether, as the prosecutor, you must defend the quality of the investigation. It almost goes without saying that in modern times, the media cover investigative techniques so much that to not consider the quality of the investigation, whether defending or prosecuting a criminal case, to not consider that issue is a mistake. I'm going to give you now a little memory device or mnemonic that I've used to prepare many a witness when I was a practicing lawyer. Witness preparation is critical, and if you have a high volume trial practice, you need to systematize your preparation of witnesses in order to do a good job. And you need to cover a wide variety of points in a time-effective amount of time. So here's a list of what I'd recommend you advise each witness that you're preparing. Number one, you tell the witness that it is important to tell the absolute truth, and to not do so is a huge mistake and is possibly a criminal offense when done intentionally and as to a material issue. You should tell your potential witnesses. They should not shade the truth on small details in favor of whatever side they perceive that they're testifying for, because the jurors, in their collective wisdom, that group of 6 or 12 or 14 people, can often tell that they can often determine that you're not telling the truth when you shade the details, shade the truth in small ways to favor one side. A defendant in a criminal case should always have people in court to basically support the defendant. Jurors absolutely notice whether the defendant, and sometimes other persons with an important stake in a case, have people in court, silent people who do nothing but watch from the audience quietly without saying a word, but there to express their support. Jurors always notice whether the defendant has family or other friends there who care about what happens to him or her. Usually, the defendant or any witness should dress conservatively. Now, some folks, very experienced trial lawyers, believe that it's a mistake for a witness to change the way they dress for court. Some believe that it is better to just come to court and testify just as you normally would. My view is different. I recommend dressing conservatively, and yes, maybe dressing up a little bit. You should advise witnesses to always be courteous to everybody, even to the other lawyer. Even if the other lawyer, the cross-examining lawyer, is obnoxious, because jury nullification enters into some of these cases, and sometimes a jury's examination of the credibility of what you say has a lot to do with how much they like the witness. Some folks will be more likely to believe a witness that testifies in a way that causes the jurors to like the witness. A good witness understands the pace or timing of their testimony. It's probably a mistake to get too involved in over-preparing witnesses, but it's useful to explain at least once to a potential witness that most people, when they speak publicly, and do not do so often, do not do so routinely, most people think that they're talking too slow. But for an inexperienced public speaker, when you think you're talking too slow, you usually are talking at the right pace. So you should usually advise a witness who is an inexperienced public speaker to slow way down. In our culture, witnesses should make a reasonable amount of eye contact. This does not mean to be like an extremely practiced or professional witness. This means to look at some of the jurors, perhaps all of them at some point during your testimony, and to even look over their heads, because jurors or anybody cannot tell that you're looking over their head rather than directly at them. Advise your witnesses to not use any legalese and not use any police language, just as the trial lawyers should not use that kind of language. It sounds phony, and it only separates you from the jurors that you use language. And examples would be things like the word vehicle. Most people do not use that in regular, normal conversation, and witnesses and lawyers should not also. Advise your witnesses to answer only the question and not to add anything more. If it's that important, and it usually is not, the lawyer can come back to it for a redirect examination. Give your witnesses a basic understanding of objections and, most importantly, not to talk when the judge is talking, and to wait for a ruling on the objections, and try to get the witnesses to have a basic understanding of how objections work. Tell your witnesses it's perfectly okay to be nervous. You might be surprised to know that jurors are fairly nervous themselves, and when a witness is nervous and betrays some of that nervousness, it gives them something in common. It gives them a common experience. Advise your witnesses not to argue with the lawyer for the other side. The rules of court give much greater advantages to the lawyer examining the witness, and arguing with the lawyer is usually a lost cause and will make you appear biased in trying to foist an agenda on the jury. In addition to the pace of how you talk affecting the pacing of your testimony, a witness should also wait until a moment or two after each question. This gives a witness a chance to think and to formulate a decent answer to a question. And if it's done at a uniform amount of time, it is something that cannot really be detected. It sounds completely natural. A witness should not be exact about details unless they're really sure about those details, because with the passage of time, everyone's memory gets much worse. So don't be exact about details unless you're really sure about the details. And finally, on this list of general things to discuss with witnesses, discuss with them sensitive areas, so that, for example, the girlfriend of a defendant would not want to discuss that the defendant has been locked up in MCI Walpole while awaiting trial, because this is something that the jury is not told. You want to teach your witnesses about certain sensitive areas that jurors are not told about in every case. Now, a couple of more tips for criminal trial lawyers. Avoid chronologically organized evidence or argument. It's a mistake to give an opening statement or a closing argument that is organized by a witness or by the order of evidence in a case. Jurors want you to organize the case for them. They don't want you to regurgitate the evidence and for them to have to organize it themselves. You want to add value to the trial. You don't want to just repeat it for them. You want to organize it and make it easier for them, and to lead them in organizing and understanding the evidence. Consider the possibility of conducting extremely small focus groups in preparation for jury trials. This can be done with as few as 2 or 3 jurors in which you conduct a mini trial in a conference room in your law office, and it can be done by the prosecutors or defendants. And then after, for example, a 1.5-hour trial with a lawyer standing in for the other side, with many opening statements and many presentations of key witnesses, one simply has the jurors deliberate, and it can be 2 or 3 friends, family, or other persons, and you turn the video camera on, and when you get that 40 minutes of deliberations on video and watch it later, it can give you valuable insight into the key factual and sometimes legal issues in a case. Finally, remember the importance and the critical role that the use of a theme plays in criminal trials. A theme is absolutely essential, and a strong criminal trial lawyer, whether a prosecutor or defense lawyer, hammers at a theme that organizes the entire case from the beginning, from the very beginning of the opening statement, through the opening statement, through that theme is apparent through the entire trial and all of the witnesses, and then hammers it home again and again in the closing argument. Most lawyers underutilize themes, and I advise you to heavily use themes because they are key to persuading jurors of the justness of your cause. Good luck.